Now, I'm not one to gossip, but I will bring you the tea. Welcome to Chronicle Speaks.
Please, I don't have any time for any gossip now. Eh? Yes.
Look at you.
So here we are at part 2 of my Wendy Williams docu-series. Now, in the last video, we explored the explosive lawsuit filed by Wendy Williams' ex-husband, Kevin Hunter, against over 40 individuals and entities connected to her guardianship, including her court-appointed guardian, judges, doctors, lawyers, Wells Fargo, and much more. Now, the video explored how Wendy was allegedly forced into guardianship in 2022 before they stated she had frontal temporal dementia and aphasia. We spoke about how she's been isolated, restricted, and financially exploited ever since. We mentioned how her accounts were frozen without notice based on a questionable letter from a doctor who was paid $60,000 by her financial advisor, Schiller, who used that same letter to justify the guardianship. And boy, do we have a surprise for you today regarding Ms. Schiller no longer being employed at Wells Fargo, so stay tuned. We covered how Wendy was denied access to her own money while others like her ex-manager, Bernie Young, and an associate, Leah Abraham, allegedly used her funds for unauthorized personal gain. We included shocking details about how her son, Lil Kev, was cut off, evicted, and emotionally harmed, even though Wendy had legally named him as her power of attorney. Now, despite passing a cognitive test in 2025, the court still refused to release her from her guardianship. The lawsuit paints a disturbing picture of corruption, negligence, and financial abuse, raising serious questions about how the system failed Wendy. We are in the second part of a multi-part docuseries breaking down the lawsuit and what it reveals about Wendy Williams' battle for freedom and justice. We are going to get into this case and so much more, but before we do, please be sure to subscribe to this channel and hit the bell for notifications so you don't miss out on any news regarding this story and so much more. Now let's get back into it. Now, this lawsuit filed by Wendy Williams' ex-husband, Big Kev or Kelvin, pulls back the curtains on what's been really going on behind the scenes of Wendy's guardianship. For years, the media painted one picture, but this lawsuit, along with the receipts he's attached, tells a very different story. One filled with manipulation, isolation, and what looks like a complete loss of Wendy's freedom. Things have been disguised very well in the public eye, but these court documents expose a stark contrast to what we've all been led to believe. And more importantly, the lawsuit shines a major spotlight on the guardianship system itself and how easy it may be for someone to use the system to take over another person's life, finances, and freedom, all under the disguise of protection. During their marriage, Mr. Hunter served as Ms. Hunter's trusted business manager and advisor, playing a central role in managing Ms. Hunter's professional, financial, and personal affairs. Under his stewardship, Ms. Hunter's career flourished, her brand expanded, and her finances remained stable and secure. Following their divorce, Ms. Hunter was left to navigate complex financial and medical matters without Mr. Hunter's experience oversight. It was during this period that individuals such as Schiller and Bernie Young began to exploit Ms. Hunter's trust and financial resources. Schiller and Bernie Young placed themselves into positions of undue influence, managing Ms. Hunter's accounts, controlling communication, and orchestrating a campaign to remove her autonomy under the disguise of concern. Despite their divorce, Mr. Hunter has remained involved in Ms. Hunter's life and possesses personal and familiar knowledge relevant to Ms. Hunter's capacity, care, and treatment, particularly during the period of concern giving rise to this complaint. As such, Mr. Hunter is well positioned to serve as next friend to Ms. Hunter under federal law, where a party may act on behalf of an individual unable to assert their own rights and when no guardian is acting in the best interest. Say what you want about these two, Kelvin definitely kept Wendy protected when it came to these vultures, and the minute they divorced, they swooped in and took over. Part 1 only gave you a peek of what's been going on under this guardianship. Let's go ahead and get into part 2. Upon information and belief, in or around March 2022, in Judge Sokoloff's chambers in New York, Lisa Sokoloff told Ms. Hunter that she would regain access to her finances if she consented to the guardianship. Of course, if a guardian were appointed, the guardian would have access to Ms. Hunter's funds, not Ms. Hunter herself. Based on Judge Lisa Sokoloff's statement and following the continued deprivation of Ms. Hunter's rights and financial hardship caused by Wells Fargo freezing her account and initiating the guardianship proceeding, Ms. Hunter, under immense financial duress and emotional strain, was coerced into consenting to the appointment of the temporary guardian. On or about March 15, 2022, 4 days after suspending Ms. Hunter's valid power of attorney without due process, Judge Lisa Sokoloff issued an order appointing Sabrina Morrissey as temporary guardian with plenary control over Ms. Hunter's financial accounts, medical decisions, legal matters, and communication. Judge Lisa Sokoloff imposed the guardianship based on Ms. Hunter's coerced consent and based on deficient and fabricated findings of incapacity, lacking clear and convincing evidence as required by New York Medical Hygiene Law 81. Upon information and belief, Judge Lisa Sokoloff routinely appoints Sabrina Morrissey to serve as guardian in Article 81 proceedings, despite Sabrina Morrissey being accused of being a party to a scheme to falsely imprison someone under an oppressive guardianship. Following her appointment, Sabrina Morrissey immediately took control of Ms. Hunter's bank accounts, assets, and personal decision-making, including medical treatment and residency. Wells Fargo permitted Sabrina Morrissey to liquidate assets and transfer funds in violation of internal bank policies and fiduciary obligations. So what this is basically saying is that because Wendy Williams was essentially broke, emotionally stressed, and still locked out of her bank accounts with Wells Fargo, she felt forced to go along with this guardianship, not because she wanted to, but because she felt forced, like she had no choice. Coercion. So let's talk about attorney LaShawn Thomas. This is the attorney that Wendy actually chose to represent her. Wendy hired LaShawn herself, not the court, not the guardian. Wendy, that's very important. Attorney LaShawn Thomas is part of the Miami Entertainment Law Group and was speaking out for Wendy since all of this started. She was the one trying to step in to help Wendy regain control of her life, her finances, her medical decisions, everything, but the court didn't want to make that easy. In fact, when LaShawn filed paperwork to officially represent Wendy, Judge Lisa Sokoloff told all of the parties not to share anything with LaShawn's legal team. So even though Wendy made her decision, the court basically iced her lawyers out. Let's get into it. Despite Ms. Hunter's retained counsel filing a notice of appearance in the guardianship proceeding on or about March 17, 2022, Judge Lisa Sokoloff instructed the parties not to share any filed documents with Ms. Hunter's retained counsel. Because of this, Ms. Hunter's retained counsel was left in the dark with the inability to advocate for Ms. Hunter's best interest. True and correct copies of this email exchange between Judge Lisa Sokoloff and the parties from March 18, 2022 through March 28, 2022 are attached hereto as Exhibit K. Now, Associate Attorney Celeste McCall, who works alongside Attorney LaShawn Thomas at the Miami Entertainment Law Group, sent the following letter to Judge Lisa Sokoloff on March 18, 2022. Good evening. It has come to my attention that all parties involved have been given the dates of next Tuesday afternoon and Wednesday morning or afternoon for the in-person Lincoln hearing to be held. However, I have not received such proposed dates. Nevertheless, I am not available on either Tuesday or Wednesday to attend the proceeding in person as I have other commitments. As such, should a date for the Lincoln hearing have been set without my knowledge for either Tuesday or Wednesday of next week, then I respectfully request an adjournment. Please be advised that if I am not present at the Lincoln hearing, Wendy Williams Hunter will also not be available to attend. As Wendy Williams Hunter's counsel of choice, Miami Entertainment Law Group has a right to be present, and we kindly request to be included on all correspondence regarding the matter going forward. Best, Celeste McCall, entertainment attorney. Well, on the next day, 9:35 a.m., Judge Lisa Sokoloff wrote to Ms. McCall and said, Ms. McCall, only certain individuals are permitted at the Lincoln hearing. I advise Ms. Thomas as a courtesy. A firm does not represent an AIP, only an individual. If Wendy Williams Hunter is not presented, then I can't determine whether she has the capacity to select her own counsel. Without that determination, Ms. Redlisky remains her counsel. Judge Sokoloff. So after that, attorney LaShawn Thomas sent an email to Judge Sokoloff. It's pretty long. I'm going to summarize it because there's one that I actually do want to read to you. Now, this letter challenges several major decisions made by Judge Lisa Sokoloff, starting with the fact that the court appointed both a temporary guardian and attorney Linda Riliski without making any official finding that Wendy Williams was incapacitated. LaShawn points out that Wendy never consented to these appointments and that her own repeated requests to not be represented by Riliski were ignored. She even shares a disturbing incident where Riliski allegedly made a rude and antagonizing comment to Wendy Williams' son, Lil Kev, inside Wendy's home, something that upset Wendy deeply and, according to LaShawn, was never reported to the judge. Let me read that part. So LaShawn says this: Wendy Williams Hunter has empathetically expressed that she does not wish to be represented by Ms. Riliski. This is especially true after Ms. Riliski went into Wendy Williams Hunter's home and made intentionally antagonizing comments to her son in front of her, upsetting her in her own home, specifically as Ms. Riliski departed Wendy Williams Hunter's home. Ms. Riliski told Wendy Williams Hunter to have a good night, and then she said to her son, "Not you, Kevin," upsetting Wendy Williams Hunter. Ms. Riliski's conduct reflects poor upon not just her professionalism, but also this court. I have audio-visual footage of this interaction, and I am positive that neither Mr. Solomon nor Ms. Riliski reported her comments to you. From the outset of this proceeding, the court has unfairly disadvantaged my client and I feel has displayed an unwarranted bias against Wendy Williams Hunter and my office as her selected counsel. Now, LaShawn goes on to defend her own credibility as Wendy's longtime attorney, saying that her team hasn't leaked anything to the press and pushes back against the court's attitude towards her office, calling the court's request for a confidential agreement prejudicial and condescending. She asked the court to give Wendy time and space to properly defend herself, to stop rushing the process, and most importantly, to let Wendy stay in Florida, where her doctor and her family are, instead of forcing her back to New York, where she has no support. Her message is clear. If the court really cares about Wendy's well-being, it should start listening to Wendy, not just the people trying to control her.
Well, by now you know exactly who Lori Schiller is for me. Not good. I began to ask questions about what's going on with my money. And she's got no answers for me. She's got no answers for me. This is very unfair. Wells Fargo is very unfair. They don't have any answers regarding my money. Lori Schiller and Wells Fargo have no answers regarding my money. Lori Schiller and Wells Fargo filed a guardianship petition because I want to know what's going on with my money, and Lori Schiller and Wells Fargo have not any answers for me regarding what has happened with my money that I've worked so hard for all of my life, but particularly now, more than ever, because I don't know what has happened to my money. And Bernie Young, oh yes, you remember Bernie Young. Bernie Young and Lori Schiller, I believe, are hand in hand working against me with regard to this situation. I believe this. And again, this is not good. And I know for a fact that Bernie Young used my American Express card, okay, and he hired lawyers to file a guardianship against me. Against me. Can you imagine that? Some doctor sent medical information without my permission. I knew nothing about this. I knew nothing about this. Wells Fargo used their guardianship petition This is all against me. This is not for me. This is all against me. You know, the New York court system right now says that I'm crazy, that I'm crazy on what Wells Fargo is saying that I am. This is very ridiculous. The New York court is trying to make me out to be crazy, to be Ku Young Fu. Do you remember that? The Ku Young Fu judge case. Remember that? This is not me. This is not me. This is not fair.
So the email that I just read that LaShawn Thomas wrote had a few typos, but she noticed that and she resent it to the judge with some corrections. Now let me read this. This is very important. She says, "My apologies for my typos, Your Honor. I would also like to make you aware that on January 14, 2022, an unauthorized charge of $10,000 was made on Wendy Williams Hunter's American Express to Dr. Raman Kaminsky 6 days prior to his January 20th, 2022 letter to Ms. Lori Schiller. Not only is this payment and the corresponding letter suspect, but this letter was provided to Ms. Schiller in violation of HIPAA and the patient-physician privilege, as my client did not authorize the release of her medical information to anyone, inclusive of Lori Schiller. This letter was used as the basis of Wells Fargo's claims in violation of Article 81, which prohibits the use of medical records to support allegations. Additionally, as attorney Sabrina Morrissey was nominated by Abrams Finsterman, her powers should be rescinded and she should be removed, as she appears to be following direction from this firm. Abrams Finsterman is the firm that Bernie Young hired with Wendy Williams' American Express card to file guardianship against her. Ms. Morrissey's decision to rehire a nursing agency previously terminated by Wendy Williams Hunter's son seems suspicious, as there is no way she would know of this agency without being told. This agency was hired by Bernie Young. Please note that this agency was terminated when a nurse was discovered attempting to surreptitiously bring wine to Wendy Williams Hunter. I further discovered an exorbitant charge made on Wendy Williams Hunter's American Express card on January 24th, 2022 in the amount of $20,648.25 to this agency. This payment was made after their termination. Please note that Wendy Williams Hunter has health care coverage, therefore private pay is unwarranted. We will be bringing further these issues in our papers. I pray that the court does not allow the actions and statements of the petitioners to make a mockery of this judicial proceeding, as they appear to lack candor in both their interactions and statements to this court. At the end of the day, I would like to go down on the right side of this history-making case, and I ask that the court adjourn for 2 weeks and instruct all parties to provide all papers to this office immediately so that we can properly present our case. And with all of that being said, the judge says, "Ms. Thomas, it isn't the typos that bothers me. It's your entire email. You should not be emailing me ex parte. Somehow I doubt the rules are different in Florida. Moreover, I told you that you have no standing in this matter until I determine in an in-person Lincoln hearing that Wendy Williams Hunter has capacity to choose her own counsel. And I grant your admission to practice in this state on this case." Honestly, upon hearing all of that, there should have been an immediate investigation to protect Wendy Williams and her finances. However, that was not done. I wonder why. LaShawn was not letting up. She says, "Thank you, Your Honor. Unless and until Wendy Williams Hunter is deemed incapacitated, Article 81 grants her the right to select the counsel of her choosing, and until such time as this court grants me authority to represent my client as per her request, I will advocate for her via other means. Thank you for your time. Best regards, LaShawn Thomas, Esquire." So these emails continue for quite some time. Wendy is insisting on keeping LaShawn Thomas as her attorney, but the judge is said to have responded by berating Thomas in open court. Judge Sokoloff allegedly threatened to refer LaShawn to the disciplinary committee for improper conduct just for continuing to appear on Wendy Williams' behalf. As a result of that threat and pressure from the court, LaShawn withdrew from the case. What's important here is that Wendy had not yet been found incapacitated at that time, and legally someone who hasn't been declared incapacitated still has the constitutional right to choose their own attorney. This is part of what makes this lawsuit so explosive. Please note that attorney LaShawn Thomas is the last attorney Wendy Williams personally signed a retainer or agreement with. Now let that sink in. Now, while Wendy Williams' money is paying doctors $60,000, nurses $20,000, and attorneys for Bernie Young $10,000, she's falling behind on her rent. At this time, Wendy Williams' cell phone company was threatening to turn off her phone due to non-payment. Now, on or about March 23, 2022, Wells Fargo filed a motion seeking to seal the guardianship matter and to enjoin Ms. Hunter's privately retained counsel, Miami Entertainment Law Group, from representing or even communicating with her. Shortly thereafter, Ms. Hunter's phone was remotely altered. Her counsel's number was deleted from her contacts, and Miami Entertainment Law Group's phone number was blocked, effectively severing her direct access to legal representation. On or about April 21, 2022, Judge Lisa Sokoloff issued an order prohibiting Ms. Hunter's use of computers, tablets, and other electronic devices. On or about July 27, 2022, Judge Lisa Sokoloff issued a further order curtailing Ms. Hunter's access to regular telephone service, effectively placing her in near total technological isolation. These restrictions were imposed despite the absence of any adjudication of incapacity and without affording Ms. Hunter an evidentiary hearing or an opportunity to contest these life-altering restrictions. The silencing campaign escalated on or about June 1, 2023, when Judge Lisa Sokoloff issued a judicial order authorizing the public release of Ms. Hunter's private medical information, including the announcement of a diagnosis of frontotemporal dementia without her informed consent. This order also retroactively authorized HIPAA waivers, waiving Ms. Hunter's fundamental privacy rights. Upon information and belief, the release was strategically timed and intended to support a medical narrative, reinforcing Ms. Hunter's alleged incapacity, thereby foreclosing public sympathy or legal scrutiny of the guardianship. Simultaneously, Ms. Hunter's communication with her family and friends were tightly controlled. Phone usage was limited, and visitors, including her son, were required to obtain prior approval from Sabrina Morrissey. Permission was frequently denied or delayed without explanation, further reinforcing Ms. Hunter's social isolation and dependency. The weaponization of familial relationships ensured that no one close to Ms. Hunter could challenge the guardianship or assist her in asserting her rights. Adding insult to injury, defendants used Ms. Hunter's own funds to retain management and public relations agents, Will Selby and Sean Zanotti, who disseminated the narrative that Ms. Hunter was incapacitated and thriving under court supervision. These efforts were not for Ms. Hunter's benefit, but were calculated to mislead the public, insinuate the guardianship from criticism, and suppress the truth of Ms. Hunter's unlawful confinement and exploitation. The guardianship was put into place because Wendy was a victim of undue influence and financial exploitation, but yet the people that are put into place to help her caused this millionaire to be behind on her cell phone bill, caused this millionaire to be late on her rent, caused this millionaire's son to be evicted from his apartment that she wanted to buy for him outright, but was unable to because the powers that be wouldn't allow her to. Let's not forget the federal tax lien of over $500,000, right? This video is from August 25th, 2022. 5 months after LaShawn was kicked off the case as her attorney. This is what protection looks like in the New York guardianship system. Please note that the paparazzi was always where they needed to be to make sure they got shots like these. This was all by design, and they were hoping that people like you would never look at the bigger picture. Anyone that was willing to help Wendy had to go. Now fast forward a bit to January of this year. Wendy Williams had been asking Redlisky to file paperwork to get the ball rolling for a trial to decide whether the guardianship is truly necessary. Wendy Williams was upset that that never happened, so Wendy pulled the trigger and fired Redlisky. So let me take you back to early 2022, when Wendy Williams, her son Kevin Jr., and her attorney LaShawn Thomas went to a Wells Fargo branch in Florida where things started to unravel. They wanted to deny Wendy Williams being able to list her son as a power of attorney, and this is where they first tried to separate Wendy from being able to talk to them with LaShawn around. LaShawn filed a FINRA complaint explaining everything. Now, this complaint is filed on behalf of my client, Wendy Hunter, who utilizes the services of Lori Bianco Schiller, a financial advisor for Wells Fargo Advisors. Around November 28, 2021, I was approached by my client with a request to draft a power of attorney for execution. I was advised that this document was specifically requested by Ms. Schiller due to instructions issued by my client to Ms. Schiller to give information to my client's son regarding a real estate transaction that Ms. Schiller was spearheading. Ms. Schiller had previously advised my client that Ms. Schiller would save my client money by sourcing and hiring a real estate attorney on behalf of my client. Lori advised that she would charge a small fee and save my client more than $50,000 in commission. My client executed the power of attorney on January 7, 2022. This document was then presented to Ms. Schiller, who refused to accept same. Ms. Schiller then proceeded to freeze all of my client's accounts without prior notice. When my client was unable to withdraw any funds from her accounts, she presented at the local branch and advised that she could not access her accounts unless and until she spoke with Ms. Schiller. After a phone conversation with Ms. Schiller stated that she would fly to South Florida to meet with my client to place the power of attorney on file. Ms. Schiller failed to appear as planned. My client continued to make attempts to resolve this matter with Wells Fargo, both in person and on the phone. Ms. Schiller further impeded my client's attempts to access her accounts online by closing her command account and closing all of her personal and brokerage accounts. Schiller further prevented all access to my client's accounts by restricting my client's ability to download her account statements. Due to Wells Fargo's refusal to grant my client's access to her account, my client instructed this office to file a TRO, and in response, Wells Fargo filed a petition for guardianship. Please note that prior to the filing of this document, Wells Fargo has never made any accusations of undue influence or financial exploitation. Schiller violated the law by offering to hire an attorney to draft a real estate purchase agreement and keep the commission safe by foregoing use of RE broker law, by refusing to provide financial information for inspection, by refusing to add my client's son as an associated person per request, for failing to obtain a trusted contact for my client's account, by placing a blanket hold on all of her accounts and blocking and preventing even legitimate transactions without notice to my client, by failing to conduct an internal review to determine the facts and circumstances supports its position, and failing to report findings to Adult Protective Services for handling. Wells Fargo is in violation of the law for its failure to investigate my client's complaints against Ms. Schiller within 30 calendar days, and FINRA's code of conduct by opening more than 18 accounts without sufficient jurisdiction, causing my client to inquire excessive fees and commissions, and initiating wires without written permission. This is the very reason why they did not want LaShawn on the case. She was calling them out one by one. To me, it looks as though they were planning to pin all of the spending on Lil Kev anyway, and getting Wendy to fill out the power of attorney on his behalf and bring it back to the bank was the catalyst to get all of this started. So this document I'm showing you now is completely accessible and free online at brokercheck.finra.org. Let's get into it. It states that Ms. Lori Bianco Schiller has a termination date of May 12, 2025 from Wells Fargo Clearing Services, LLC. The firm reviewed concerns related to the number and accuracy of disputed transactions on her personal card accounts, not securities account or client account related. No product. So Lori has her SIE, her Series 3, her Series 31, Series 7, and Series 66. And after being in the banking industry for over 27 years, we are to believe that she would make the foolish decision of disputing too many of her transactions that were not able to come back as being disputable, i.e. disputing transactions that you actually made, coming back saying you didn't make them so you can get your money back. Notably missing from this report is LaShawn's complaint. You don't believe me? Look at it yourself. It's online and it's free. There's also been an Instagram page dedicated to exposing everything that has been done wrong to Wendy while she's been at the coterie, things that Wells Fargo has done. And guess what? Lori Schiller had a feature on that page. And less than a month after she was exposed on this page, she voluntarily quits her job at Wells Fargo after being investigated for disputing transactions that really belonged to her. According to the documentation, this type of disclosure event involves a situation where the broker voluntarily resigned, was discharged, or was permitted to resign after being accused of 1. Violating investment-related statutes, regulations, rules, or industry standards of conduct, 2. Fraud or the wrongful taking of property, or 3. Failure to supervise in connection with investment-related statutes, regulations, rules, or industry standards of conduct. When an advisor leaves a FINRA-affiliated broker or dealer, whether voluntarily or involuntarily, the firm must file a Form U-5 with FINRA, and the reason for the advisor's termination, including any regulatory investigation or potential disciplinary action, is recorded on this form. With that being said, this form was definitely necessary, and they had to give a reason why she was leaving. Just in my honest opinion, with her working in the banking industry for over 27 years and allegedly being able to maneuver within Wendy Williams' accounts, allegedly being able to open up 18 new accounts, allegedly being able to send Bernie $21,000 and so much more, I just don't see her making a mistake this simplistic and getting caught for it and having to voluntarily leave her job. I feel as though the powers that be may know that the walls are closing in on them. What I need to do is hear from you. What do you think about my part 2 of my Wendy Williams docuseries? We have one more part left to go and you don't want to miss it. Leave a comment and tell me what you think. And you know how we do? We'll talk about it down below. Talk to you guys later. Bye. Thanks for watching, but before you go, don't forget to subscribe to this channel, like this video, and hit the bell so you don't miss out on any of my new episodes.